Hi, Michael Kushner here, and welcome back to HOA Hell, the podcast. Today I've got with me Senior Associate at MBK Chapman, Sam Kill. Sam?
Hello, Mike. Great to be with you.
Great to have you back, as always. We talked about this when we were talking about one of your cases last week or something, and I thought, you know what, I'll do an episode on this. I was planning on doing an episode on this at some point, but I kind of put it to the top. Mm-hmm. Because it's about one of the most damaging and most avoidable problems that we see in HOA disputes every day. I would say it's right up there with selective enforcement and neighbor-to-neighbor disputes, and that is an HOA's failure to repair, maintain, or replace elements of the common area.
Great topic and a critical issue that we encounter routinely.
In fact, I think we've said this before. There are probably three fundamental jobs that an HOA has. Its entire existence is designed around these three fundamental, jobs or fundamental reasons for existing. Raison d'être, okay? Right. And one of those is to secure as fiduciaries the funds, that come into you in trust, right? And another one is to enforce governing documents. And the third one is to maintain, repair, replace, whatever, the common areas. Absolutely. Literally, those are the three jobs. Okay? So when an HOA fails in that regard, that is a very, very big deal.
Massive.
A very big deal.
Right.
Okay? So.
And it has real impact on people's lives, finances, their properties.
The property values. Yeah, absolutely.
Values.
100%. It affects the day-to-day lives of everybody because, in the extreme, which we're not even going to talk about today, when you go to the extremes of that, okay, you get red tagged in dangerous conditions. Right. Remember the balcony collapses?
Oh, yeah.
I mean, that's the extreme. We're not even going to talk about extremes. We're going to talk about everyday life. We're going to talk about the very basics. Right. We're not even going to go that far because most HOAs never get to that level. Exactly. Okay, they never get to the red tag situation or collapsed decks. That's why it makes the news. It's a very big deal. Most HOAs never get there, thank goodness, okay? No, we're going to talk about real life, okay? The stuff that happens frequently, okay? And that's the important part here. So we're going to talk about what happens when the HOA fails in this regard, and it results in our clients having soaked walls or soaked ceilings or a damaged foundation, which then sets off an entire chain reaction of events. From mold to rot, Right. We're going to talk about the infestation that can occur when they ignore their duty to, when it comes to creatures and insects and other things like that, okay? But mostly water and caring for things, because to replace completely is probably the most expensive thing. Maintaining, a lot more effective. Right. So everything that your HOA owns, from the roads to the landscaping to the fences, to the if you have a pool, to all the pool equipment,
amenities,
yeah, all of that stuff costs money, and they're all considered line item assets. Okay, and they all have, and you can Google this and get these published lives. Okay, they're what's supposed to be. How long that something lasts before it has to be replaced. Roofs, it could be 20 to 30 years. There's a whole publication that's updated all the time, okay? And if you properly maintain those assets, that's when they'll last their full lives. Right. When you don't properly maintain, something that's supposed to last 10 years is probably going to last 5, which means that instead of dividing the cost of that over 10 years, you now have to come up with the money to replace it in 5. Right. Well, on big ticket items, that's when you guys get special assessments. And the bigger the ticket item, the more your special assessment's going to be. So this stuff matters to your everyday lives. So that's what we're going to talk about today. It's the horror stories that come with their what I say is not quite an epidemic, but it's pretty frequent. So here's what we're going to talk about, and here's what you guys are going to learn, I hope, okay? What California law requires an HOA to do in terms of duties and obligations regarding maintenance. And maintenance includes everything from maintaining to replacing to repairing, okay? We're going to talk about what HOAs love to do, which is the hinder, delay, and avoid, okay? or even more nefarious, to disclaim responsibility for something that clearly is their responsibility. I'm not talking about wobblers where it's maybe, we're not sure where this pipe goes.
Right.
I'm talking about the obvious stuff. You live in a condo and something's wrong with the roof. I mean, that's what I'm talking about, okay?
Yeah.
The difference between negligence and breach of the CC&Rs and why it matters in this context, how to build a legal, how to give yourself legal leverage, and why self-help repairs can severely backfire. So when to do that and when not to. That's kind of what we're going to cover today, okay? So Sam, when it comes to maintaining common areas,
Right.
What's the law say?
Well, in California, Mike, Civil Code Section 4775 clearly states and lays out that unless your CC&Rs specify or state otherwise, common area, this includes common area components and exclusive use common area components, the responsibility to maintain, repair, and replace those falls to your association.
Okay. So in other words, your CC&Rs can shift that responsibility to the homeowner.
Right.
Most don't on big ticket items in connected housing. Most don't ever do that, but it could. But unless it does, it's the HOA
Exactly.
as the default, right?
Mm-hmm.
Okay. So I would say the default is the HOA because it affirmatively has to state in there it's not the HOA.
100%.
Okay. Now you mentioned in one of our recent shows that may or may not have aired yet, but you mentioned that most HOAs actually have an addendum at the back, their CC&Rs. I've seen that a lot, but it wasn't as common 10, 15, 20 years ago. So I think it really depends on how old your community is. If you live in a newer community, I'll say in the last 10 years or less, then it's much more likely that your CC&Rs will contain an addendum of this sort. But if you live in a community older, I think it's a little bit more rare, but it could still happen. But that addendum was this table, very simple table.
It's a matrix. Yeah.
Right. That lists all the different sorts of roofs and hallways and fences and whatever it was. And it either has, it'll either have an X, in the column under HOA or into the homeowner, right? And it lays out who's got those obligations. You don't need that, okay? That's just, it's pictorial, so it's easier to go real quick and see.
Right.
But so you might look for that, see if your CC&Rs has an addendum. But yes, I agree with you completely with everything you said. So for the most part, when we're talking about connected housing, condominiums and townhomes, HOAs will routinely, and by the way, when I talk about townhomes, I'm talking about townhomes that are legally condominiums. We're going to get to that in another episode as well. Yeah. I haven't done that yet, but I'm going to explain when a townhome is a condo and when a condo, well, condos are always condos, but when a townhome is a condo and when it's not. Okay. Now, single family homes, that is separate housing that's not connected to anything else, almost never a condo, so.
Yeah.
And when I say almost never, I'm just allowing for the possibility that it might exist. I actually can't think of one off the top of my head. But the point is that when you live in a condo scenario, the HOA is almost always responsible for the following. And I can't think of a situation where that was shifted.
Right.
Okay, but roofs, pipes, exterior walls, elevated elements like staircases and elevated hallways, even exterior elevated elements like balconies, which are, you mentioned, exclusive use. And the difference between regular common area and exclusive use common area is a very simple difference. Common areas are what we think of common areas. It's the green belts. It's the roadways or the pathways. It's the little parts of the garden or the trees that aren't on anybody's property in particular. If you have amenities, it's the tennis courts. It's the pickleball courts. It's the swimming pool. It's the gym, the workout room, all that stuff. Clubhouse if you have it. So that's common area. Exclusive use common area is a type of common area that one homeowner, typically, maybe two, but typically one homeowner has the exclusive use of. And a great example of that is a balcony, okay? A balcony can only be accessed from the inside if you're not on the first floor. Otherwise, it's called a porch or a patio, not a balcony. So it's usually going to be up higher. But the only way to access somebody's balcony would be to either come in their unit and walk through their house or put a ladder up and climb up, which is a very robber type thing to do. So it's frowned on. So exclusive use is basically common area that one particular homeowner has exclusive use of just by virtue of its existence. So in a scenario that I'm painting, condominium situation, the HOAs are almost always, and again, I say almost just in case, I can't think of a situation where it isn't the case, but are almost always going to be responsible for all common areas and the exclusive use common areas. Now, some HOAs, and this we have seen, when it comes to exclusive use common areas, is in charge of major substantive repairs or replacements, but not maintenance. Maintenance being recaulking,
Sealing,
painting, sealing, and keeping clean and free from debris or water. That will often fall to the homeowner. But that differentiation is actually spelled out in the papers, in the governing documents.
Right.
So you'll see that usually in the CC&Rs. But anyway, all those things that I just mentioned, those private streets, those pickleball courts, your clubhouse, your tennis courts, your pool, your whatever, okay, your roadways, your pathways, your green belts, those are all common areas, and almost always will the burden fall on the HOA, okay?
Right.
And where it doesn't, it'll be explicitly set forth in your governing documents. Now, under 5975, if an HOA, when we talk about a number, 5975, okay, we're talking about the Civil Code because it's part of the Davis-Sterling Act, unless we say otherwise, okay? But under 5975, if an HOA fails in that fundamental obligation, remember I mentioned 3 fundamental obligations, we're talking about one of them today. They fail, California law, under the Davis-Sterling Act, on the code section I just named, empowers homeowners to enforce those governing documents by going after the HOA in this particular case.
Right.
Okay? So you have the power to use the law to compel. Okay? Now, we see a lot of boards, for a variety of reasons, try to avoid that fundamental obligation. One reason, money.
Right.
They don't want to spend it. They want to save it. They don't want to raise dues, whatever it is. It's money.
Or tenant insurance. Yeah.
Or they're afraid
Right.
of insurance.
Yeah.
Okay? Especially nowadays. Okay? So that's one big reason. Another reason is ego and idiocy. Again,
Right.
we're going to at one point do a psychological analysis of the most common types of board members that you see. We're going to do a personality
Nice.
analysis. So we're going to kind of lay board members out into some categories. I haven't figured out how many, but at some point we'll do a show.
Curious thing for me, having been on both sides. So
Yeah.
I've seen it firsthand.
So we're going to do a show on that in the near future, where we're going to create some personality traits, and then I'm going to try to say that every board member in the world, in California, falls into one of these personality traits.
Yeah.
And one of them might be called, maybe not, might be called normal. Right? I don't know. But there is a personality trait of a Karen-esque type of person. And we see this so much that it's almost, if this was movies, we'd be talking about movie tropes, okay? The obnoxious, self-serving buffoon of a board member who their entire existence is wrapped up in their having this authority over other people, especially when the budgets are big and you're talking about a big association. Right. It's really, if it wasn't happening to real people and hurting our clients, it would actually be funny to watch. But it's not funny because we know what the results are. We taped an episode yesterday that's going to probably come out tomorrow or maybe today. I haven't decided if I'm going to publish it today or tomorrow, where we showed a very funny clip from a very, very well-known hit series on Paramount Plus. I won't mention it now because I want you to tune into that. But we show a clip, and it's a very funny interaction between the main character and the vice president of the HOA. It's very funny.
One, yeah.
And so tune into that, guys. You're going to like it a lot, I promise. But that guy fell into the Karen-esque, I would say, okay? Right. Until he realized who he was dealing with, and then he came back with his tail between his legs. Yeah. But that's for another time. So we've seen lots of boards. Okay, try it for a variety of reasons. Money being one, another being personality. Yeah. Okay? And it doesn't matter how creative they get with their explanations. You can't do it. If the HOA is obligated to maintain, repair, replace, then the HOA is obligated to maintain, repair, replace. End of story. It doesn't get more basic than that. Okay? So let's talk about breach of CC&Rs versus negligence.
Okay.
A while back, during our 6-part neighbor dispute episodes that we did. We did this neighbor dispute series that's already published. So go check that out. But in one of those episodes, we talked about, I think it was the last one. I think it was episode 6. We talked about the different causes of action that we use. It might not have been 6, though. It might have been 4. I can't remember. But we talked about the different causes of action that we routinely go to as HOA attorneys. And negligence and breach of CC&Rs or breach of contract. I mean, and we'll talk about that in a minute. Those are at the top of the list, okay? So let's talk about the difference. Sam, tell me the difference between a negligent claim, a negligence claim, and a breach of CC&Rs claim.
Well, a breach on its face is when there's a failure to undertake, enforce, or meet your obligations pursuant to the CC&Rs on a face of it. Whereas a negligence claim is things like deferred maintenance, or if you had notice of an issue, or
it's negligence. It's failure to act as you should have.
Exactly, under reasonable circumstance or conditions, or given the reasonable person standard. And obviously, these are volunteers on the board, so that will be taken into account.
Yeah, they're given deference. Yeah.
Notice of an issue, haven't been notified by a homeowner, or
so what do you mean by that? I have a leak and I tell the board and they don't do anything.
Or there's a history of various failures, roofing failures, right? Water intrusions within the same building, let's say.
Let's talk about that for a minute.
Sure.
Let's talk about that for a minute. Okay, so to apply what he just said, Sam just said, into real life, here at the office, for whatever reason, water used to tend to find its way into our kitchen. It would come through our soft tile, right? And every time it rained, I would have drips, and they'd bring up a trash can and catch the water. Well, our building manager, where my office is at MBK Chapman, our building manager and the building engineer were always on top of the ball. So after the first 2 times it happened, and obviously the roofer goes up and tries to repair it, but water finds a way. And so they never know. There might be 8 pathways. But eventually, every time it rained, without us calling, he'd pop in at the beginning of the morning and say, hey, and he'd go in on his own and just pop in and go into the kitchen. And then he'd come find me and said, hey, I just came in to check. I see that you had water here. So, and then it got to a point where I would come in the morning when it was raining and there would already be something there. So he came in at night and put it there just in case. Right. That's the opposite of what we're talking about. That's being proactive. Okay. We established that there was something happening, and they acted, which is what HOA people should be doing. Your HOA board should do. They should act like my building manager and my office is building engineer. Okay. But when they don't do that, when they ignore it, when you complain, hey, every time the landscaper puts on the sprinklers, it is spraying into my weep screed, and I'm starting to notice maybe there's a pipe under there that is clogged now because of leaves or whatever, but I'm now getting water intrusion in my house. If the HOA doesn't go and redirect that sprinkler and you suffer damage, that's negligence, and now they're liable for your damage.
Right.
Go, what were you going to say?
Well, a huge one is investigating, right?
Following up.
To investigate, I mean, that would be a reactionary type of response. How do they react and respond to a reported incident? But they also have this inherent duty to investigate, and that goes to their maintenance obligations.
But only if they have reason to know of the problem.
Right. But also periodically on things like a shared roof component.
That's not investigating. I understand what you're saying. Yeah. I call that part of maintenance.
Correct.
We're going to get to that.
Right.
Okay. There's a difference between repair, maintaining, and replacing. Correct. We'll talk about that briefly right after this section. Okay. Right. But I'm going to get to that.
Got it.
And I agree with you, but I wouldn't call that investigation. I would call that a duty to maintain.
Okay.
You can't maintain something if you're not looking at its condition.
So in other words, being proactive.
Yes. Yes. But we're not talking about that. We're talking about when they are notified about something that is happening and they fail to act. Let's say, because we're talking about negligence right now, okay? Let's say I'm in my house. It doesn't matter if it's a condo or a house. There's a big common area tree, okay, a nice elm tree, and lightning strikes it and the tree falls through my living room, okay? Obviously massive damage, blah, 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 okay? The HOA is responsible to replace the tree. They can't not replace it. They can't say, well, tree's gone. They have to actually replace it. But they aren't going to be responsible for replacing my roof if it's my home, if I'm in charge of the roof. If it's a condo, yes, they are. But if it's not, if it's a single family home and I own that roof and I have full maintenance responsibilities, I go to my insurance and say, hey, a tree fell through my roof. Act of God, okay? They aren't going to be liable to pay for the piano that the tree smashed. They aren't going to be liable to repair my roof or fix my windows. Because that tree, unless that tree fell for a different reason, which we'll get to. I'm talking about lightning. That's why my hypothetical included a lightning strike. Tree was fine. Lightning made it go bye-bye, okay? That's not their duty. They couldn't have anticipated that. They can't. It's nothing negligent about not knowing that lightning can strike, because lightning can strike, okay? So no issue there, okay? There's no negligence. They're not responsible for your damages. You're just responsible for whatever they're responsible for. In this case, it's just the tree under my scenario. If I lived in a condo, then they'd have to replace the tree and fix the roof and the wall and the glass, but not my piano, okay? Because that's personal property. But what if it wasn't a lightning strike? What if the tree was rotting? It was dying. It was just the tree was starting to go further and further as time was going on. And it was only a matter of time before it went roots up, okay? And if I notified, even if I didn't, it depends how long it was like that. The HOA would have a duty to have known that. Remember, the standard is knew or should have known. If a reasonable board in their environment under reasonable conditions knew or should have known, then it's going to be negligence. Or if I put them on notice and said, hey guys, I live in this unit right here, and this tree's leaning in my direction and it doesn't look healthy. Can you please check it, because I'm worried it's going to fall through my living room? If the board ignores that or doesn't check it, and that tree does go down and damage, then like before, they're going to be responsible for replacing the tree, because you can't repair a tree. It's dead, okay? They're going to have to replace the tree. They're going to have to replace the roof, the glass, all that stuff. Or if I'm in a single family home, just the tree. But they're also going to have to replace the roof, the glass, and my piano, and my wood floors and my carpet, and anything else that got damaged, because they acted negligently. And that's the difference. Okay? Exactly. Now, with a breach of CC&Rs, we talked about this in that other episode, and so I'll just briefly go over it. But even though it's called an equitable servitude, the document, how the law looks at it, it treats CC&Rs as if it's a contract. So the courts look at CC&Rs and treat it under California's contract law, contract theory. So we speak in terms of breach of contract, even though the cause of action might not be called breach of contract. Be called breach of governing documents, breach of CC&Rs. But the elements are going to be contract elements, okay? There, they breached, they've literally failed to do something that they were obligated to do in writing, okay? And that caused damage, blah, blah, blah.
Failed to perform, essentially.
They failed to perform. Now, in many cases, you get slightly different remedies between negligence and breach. For example, depending on the degree of negligence, this is just one example I'm going to give you about the difference and what you might get or not get. When you allege a cause of action for negligence, so if you can meet the elements of negligence, there are situations where you're entitled in some ways to emotional distress, depending, okay? But in breach of contract, you're never going to get emotional distress damages for breach of contract, okay? It's just not really one of the elements. So you get something by alleging, that also. Now, we always allege both. We have multiple different theories. We might have 10 causes of action, okay? Negligence might be one of them. Breach of CC&Rs will be the other one, and whatever else we come up with. Depending how serious it was, could be a fiduciary duty breach.
If it's serious and
could be a nuisance. Who knows?
Exactly.
It could be all of them. So we always allege multiple, but that's the difference between the two we're talking about. Now let's talk about, I think we were going to come back to something right after that.
Well, I think you covered it all. I mean, the three main ones, and also referring back to the previous episode, I think it was episode 4 or 5. The three main ones would be breach of contract or equitable servitudes.
No. I thought we were going to cover something, and you jumped ahead, and it was the duty to investigate. I want to cover that real quick. Okay, let's deal with that real quick, all right? And I did touch on it a minute ago. You might have gleaned from the examples I gave with the tree on negligence that HOAs have a duty not only to investigate affirmative complaints or issues, so that things don't get worse. That's the whole point. But as part of their initial duty that we talked about at the beginning, the three things, right? They have the duty, I'm sorry, the wrong thing, not the three things. The duty to maintain, repair, replace. Okay. Those are different. Let me give you a quick description of what that is. Okay. A duty to maintain is a duty to take care of. Sometimes that's as simple as cleaning it up frequently so it doesn't get clogged and cause holes.
Gutters, yeah.
Sometimes it's repainting so that you avoid rust, because what does rust do? Rust eats away and erodes. If you paint when you're supposed to, those paints are anti-rust. Those outdoor paints are designed.
Prolong the lifespan. Yeah.
That's right. All of that maintaining is taking care of it so that you maximize to the maximum extent of their expected lifespans, you're maximizing the lifespan of that asset or that element. Okay? And like I said, it could be as simple as cleaning or painting or tightening, whatever it is. Or sometimes it's, water pool somewhere. You go every time there's a water event like a rain or whatever, or sprinklers, you suck it out, right? You don't let standing water collect. That's maintaining. Yeah. Replacing or repairing. Let's do repairing. Let's do repairing next. So when you maintain or when you're looking, as part of maintaining, you have to investigate and look. You got to use your eyes. You got to maybe touch it. Oh, there's some rot there, right? If you have wood rot, you scrape it out and you Bondo it or something, right? Or you replace that piece of wood. Right. That's part of maintaining, which it implies as an automatic that you are also investigating, okay? Right. Now, when you look at something, you say, there's a problem, like the Bondo thing. That's the replacing part, or repairing part, not replacing, sorry. That's the repairing part. That's where you replace something or you fix it, right. Okay? You see some rust, you put a piece of metal over it, like you do the little welding thing. Mm-hmm. You clean the rust off to get rid of the chemical reaction, to stop that in its tracks, and then you fix if there's a hole there, you fix it, okay? It's not Bondoing, but it's the same idea with metal. That's part of repairing, okay? If a balcony is loose and it could cause danger, you tighten the balcony. You reglue it, you rescrew it, whatever it is, okay? Whatever fits. And then replacing is, it can't be repaired, or it's beyond its lifespan, right. You get a new one. Mm-hmm. Well, the order that I presented those, maintain, repair, and replace, happens to be the order from least to most right. of the costs involved. It's cheapest, most expedient, least expensive to maintain. It's more expensive to repair, and it's much more expensive to replace. So obviously, that's the order that they should be doing things in, right. Okay? When the HOA fails to do that is when it can be negligent, okay?
Yeah. One critical addition, and I know you alluded to this, Mike, but it can't be just a simple, board member or manager with a clipboard walking and investigating, inspecting,
yes.
determining what ought to be maintained, what ought to be repaired and replaced. This has to be done, the investigation, the due diligence really has to be done by people who are qualified. So this could be a licensed landscaper. It could be a roofer. It could be a contractor. Yeah. It could be, for more serious things, a structural engineer. Right.
Now, to look around for rust, yeah. or those things, I think anybody could do that. Yeah. But when there's an issue that somebody might be unsure about is when you need to get the proper expert to come look at it. Right. You need a more experienced set of eyes. So I think the board, and good boards do this frequently. You'll see board members in my HOA, I happen to know, because I provided some unpaid for consultations. I want my community to run smoothly. Nice. And they know what I do, so they come to me. And I've met with the board. They do this once every 2 weeks. But the board, 3 or 4 board members, do a walk around the neighborhood. Okay, it's ours, a small community. It's only like 70 homes or whatever. So they do a walk around the neighborhood and they look at the major issues, right?
Good for them. Yeah.
Okay, and now when they see something that they don't understand or that doesn't look right, then they bring whoever it is. Yeah. Okay, depending on what the nature of the issue is. Okay, now let's do a case study about one of our cases regarding a slope. So for those of you who don't know, especially if you live in Orange County or you live anywhere next to a wildernessy area, okay, where there's hills or mountains or whatever. Here we have the Saddleback Mountains, and we have a lot of Laguna Ridge and all that stuff. Mm-hmm. There's a lot of land, empty land, wildlife kind of thing, right? So you're gonna have a lot of slopes. Almost always HOAs are in charge of at least a portion of slopes, and they're usually in the rear. Okay, so this case is actually a rear slope. We had a client that lived in Orange County, can't remember where, backyard slope. So beyond where their fence was for their yard, that slope might be their property. Like if you look at the map or their legal description, their property might include that whole slope, but it's not usable, and they're not allowed to use it. It has to stay slope. So they put their fence up right at the top of that slope, or maybe even a retaining wall, I don't know, but depending on how it's situated. And the HOA will usually have to maintain the slope, even though it's theirs, because they're not allowed to use it, okay? So we had a slope in this situation where the HOA was in charge of maintenance, okay, and repair. And there was a drainage system underneath that slope. Now, a lot of HOAs, especially in South Orange County or anywhere where you're in a fire zone, okay, the hillsides or slopes in such neighborhoods are often going to be underground. You're going to have the PVC piping. And the reason for that is twofold. One, well, really onefold. I say two because it's a dream. So forget I was thinking maybe in a real fire they could actually put the sprinklers on, but I actually don't know if that ever happens.
Right.
That's not really the reason.
Nice try.
The reason those sprinklers are there is to keep all the plant life, in this case it was those ice plants, to keep them alive and green, because green plants are harder to burn than dead plants. Dead plants are fodder for fire and they go up very quickly. Live plants are a little harder to ignite, and so that is a fire barrier, okay? And the reason plants are planted on hillsides is because it's what holds the hillside in. When you have plants with roots, those roots contain the hillside. That's why after big fires, you have the risk, you always get the first rains that come. The news is always telling you, careful for mudslides, because all those plants were burned away and there's nothing holding the soil on top of those slopes, and it could come down in a mudslide. But when you have green coverage, ice plants, grasses, whatever it is that they plant, when it rains, it holds the soil. That's the point of that. And so the sprinklers that are underneath keep the plants alive as a natural fire break, and the plants themselves keep the hillside alive by not allowing it to fly down to the streets, into your neighborhood or into your homes the first huge rain that you have. So we have a slope with the greenery and all that, and the sprinklers are there just like they always are, okay? So our client spending time in her backyard and notices they had some heavy rains. A couple years ago, we had these really heavy rains. Notices this little valley or this crack in the slope where the earth had come apart, right? Even those sprinkler things were actually visible. And they're like 18 inches under or whatever, or however long it is, right? Because that's what keeps the soil wet. Well, this ridge or split that formed was worrisome to her because it was up at the top where her house is. So she notified the board and she sent an email. Hey guys, and even took a couple pictures, uploaded them, said, hey guys, this is from my backyard looking down onto the rear slope. This isn't normal. This just formed. I'm a little worried about it. Could you guys come out and take a look and tell me what I need to do, if anything, or maybe fix it or fill it in, whatever, okay? Very reasonable. No thought that there would be an issue here, okay? Nothing. No email from the management company or anybody on the board say, thank you, we'll take a look. Wow. No response whatsoever. Silence. Ignored it. I think I've said it enough, right? Okay, nothing. Then she was worried enough to where she just called a contractor that she'd used. I think it was her landscape contractor, but whatever, and had him look at it and said, is this something I need to worry about? Guy said, absolutely. This is a problem.
Good for her.
Gave her some reasons. Yeah. She paid him. It wasn't free. She paid him. She sent a copy of the invoice and the comments that the guy made. It wasn't a formal report, but it was comments to the same people that she'd sent the original email. Hey, I had my licensed landscaper. Here's his license number. Here's some pictures he took. Here's what he told me. I'm as concerned as I was before, but now more so. I'm more concerned now. Think she got a response? No. Nothing. Nobody even acknowledged. We'd still be telling this story if she got a thank you, I'll take a look, and then nothing happened. We'd still be telling the story, but at least there would have been a response. This was silence. Well, the crack spread, and now it damaged the fence and then went underneath and started damaging, was heading to the pool and was damaging her backyard, okay? At this point, she comes to us. So you have part of this patio is cracked and it's heading to the pool. And she comes to us, and by the time she came to us, she'd spent in investigating and repairing the damage that had already been done. By the time she got to us, she'd spent about $3,000. So not a huge amount yet. It's a lot of money. Don't get me wrong. $3,000 is a lot of money, but it could be a lot worse. I'm sure you'll agree. If I'd gone to the pool, it would have been triple that, okay? Or double that. But at this point, it's $3,000, so we get involved. At first, we sent a little notice that we call a notice of representation. It was kind of part of what we send, and it included a $5,200 demand, Okay, and we asked for a whole gamut of documents. If you want to know about the 5200 demand, check out the podcast that we just published recently on the power of that thing and how much of a weapon that is for homeowners. But anyway, we set the 5200 demand and we got response. It turned out that a couple years prior to this crack forming, the HOA had stopped investigating all of the slopes because they used to have their licensed expert, some landscaper guy, do the inspection with them every year. But that was expensive, and they were trying to save money because they didn't want to increase. Prices of things had gone up, so much so that the only way they could have continued with the services that they already offered and paid for all the increased cost, not only of labor, but of the supplies for every vendor they had, was to cut some services out, and that was one of them. So they didn't want to raise people's regular assessments. Right. Well, they stopped investigating. Negligence.
Yeah.
Okay.
Exactly. Yeah.
So once we figured that out, our demand letter was, okay, thank you. A, have somebody go out there and investigate. B, fix it. And C, since ours is already fixed, give us a check. Mm-hmm. Now, remember, in my scenario here in this story, our client tried twice to get them to do their job before her damage occurred, and they didn't. This is why she was able to engage in self-help. We'll cover that at the end.
Right.
Guess what, guys? They said no. Okay, fun. So we go to mediation. Okay? The mediator, retired judge, the Orange County Superior Court, made it crystal clear to they and their lawyer, you guys, there's no debate here. This isn't even I don't know why we're here.
Yeah.
You guys should have negotiated something before coming to mediation. Because if this goes to court, you're going to get creamed.
Right.
Judge said that. I'm not quoting him, but in no uncertain words, that's the message. Board didn't make a reasonable offer. Okay? Which was insane to me. I can't explain why. I have some theories, but it relates to the quality of the lawyer at that time and the specific law firm involved. So I'll leave that at that. So we file a lawsuit. This is one of the few times when the insurance company took a look at things sooner rather than later. Mm-hmm. The case settled pretty quickly. At the end, when we settled this case, the HOA agreed to start abiding by the governing documents, which meant those inspections had to start again. Everybody's rates did go up, by the way, but so what? Mm-hmm. Okay, it's cheaper to do that than it is to repair everything when it happens.
Yeah.
So one of the stipulations in the settlement was that the HOA had to abide by the governing documents, and it specifically said including regular maintenance inspections. Okay? So now if they didn't do it, they'd be in contempt. They'd be in breach of the settlement agreement because we put it in word for word. Second thing they had to do, they had to pay every dime back that our client spent fixing her thing. And I think at the end it was like $3,700 something. Okay? Third thing they had to do, they covered every bloody dime of her attorney's fees. 100% of her attorney's fees. She was not out of pocket one penny because we wouldn't have settled. Okay? It ended up costing them infinitely more. Oh, and then they had to repair the thingy.
The pool, the crack.
No. She already did that. They had to repair the slope crack.
Oh, okay.
They had to repair that so it wouldn't keep spreading. They had to fix the issue. So, and there were some cracks starting in other slopes, but nothing had gotten as bad as this one for whatever reason. The geographical way it was situated. Point is, guys, they paid every dime and more. And had they just, when she first emailed them, it would have been, I think, 10 times less. Okay?
Well, that's a fantastic outcome.
Yeah. And I'll tell you, we get those outcomes more often than not because by the time it gets that far, we want our fees.
And by the way, her self-help after all those initial attempts, good faith attempts, were mitigating damages.
Right. So let's talk about the difference between mitigation and self-help being a problem, okay? Just because your ceiling is leaking, assuming that the ceiling is HOA responsibility, and that's a big if. You got to look at your governing documents. But let's say it was, just for purposes of my analogy here. It doesn't mean you can fix it yourself, okay? Yeah. You have to jump through a couple of hoops, okay? unless your CC&R specifically allow you first shot at. Some do. Again, read your documents. If your CC&Rs actually allow you first shot at repair and then you send an invoice.
Right.
Some do. That's okay. Follow what it says. You can't do more than that. But if it doesn't, Sam, what do you have to do? What should you do?
Well, you should report it in writing, document any issues, damages to the extent you can, taking photographs, videos.
This is your mantra, isn't it?
It is. I mean, it's a common theme that we keep repeating.
It's your common thing. I'm going to let you take ownership.
No, it is. It is. I mean, I say this religiously. I mean, it really helps you as a homeowner, empowers you. It puts the onus and burden and the notice on the HOA, and we spoke to the impact of it in terms of a negligence claim potentially. And then it also helps your attorney prospectively. If we need to, get engaged, which I would say you set, you do all those steps.
Like our client did.
You set a reasonable deadline. You don't tell them like, hey, respond to me within 24 hours, but you give them a reasonable time frame,
right.
And they fail to acknowledge.
Unless it's an act like there's active water intrusion pouring in, then they have to act immediately.
Like in your case, the case you just
right. That didn't require next day.
Next day, but no one responded. Despite her
ignored
repeated attempts.
Twice.
So when that happens, then you come to an attorney like us.
Right. We're going to talk about when to come to the lawyer.
Right.
Point is, if your CC&Rs say, go ahead, do self-help first and then notify the HOA with an invoice, do that. Most of the time it doesn't say that. You got to give them a shot first, like our client did. You've got to notify them so they can act. A lot of boards, there are boards that act in good faith, and the good faith boards will jump on that and say, hey, thank you for notifying us. I'll send somebody out. We might knock on your door so you can walk us out there. That's a great thing if they do that. You're lucky. Okay, you want that. That's the engagement you want. Yeah. But if that doesn't happen, then you go forward. Now, when do you come to us? Okay, when do you lawyer up? Well, you lawyer up when your efforts, reasonable efforts, have failed. When that has failed, that's when you come to us at MBK Chapman, because we'll set your HOA straight. That's what we do. There's a reason that we call these common area nightmares, because when bad things happen to the elements in the common area and they're not maintained or replaced, nightmares do happen. You get leaks, you get dangerous conditions, you get a whole bunch of things that happen. It costs people money, time, resources. It's completely avoidable. Okay? Everything degrades. Entropy tells us that. Everything degrades over time. Right. But things that aren't taken care of degrade much quicker, much more quickly. And the HOA is supposed to anticipate that and take care of it and be budgeting for that so that when they are taking care of it, at the end of that item's useful life, they have the money already in reserve to replace the item. That's what's supposed to happen. So the takeaway here is hold your HOA accountable to its obligations under the governing documents. Do not let them fail you and potentially cause damage to your personal property or the safety of you and your families by failing to abide by their very important fundamental obligation. And when your efforts fail, you come to us at MBK Chapman and we'll make sure that we hold your HOA accountable. This has been another episode of Podcast Hell. I hope you enjoyed it. If you did, please hit the like button. And if you haven't done so already, please subscribe to the channel. If you have a question or you want to leave a comment, we'd love to hear from you. Until next time, have a wonderful day.